This afternoon, which is on serving as guardian ad litem in probate court. My name is Kelly Tages. I'm the director of pro bono at the Chicago Bar Foundation. I won't be doing anything here today other than giving you a little bit of information before we get started. As most of you know, this CLE is being offered complimentary as part of Pro Bono Week. And as part of that, we ask in the spirit of Pro Bono Week that you take on some kind of pro bono case in the next 6 months. Obviously, serving as a guardian is a great way to do that if you want. Or if you're interested in another area, there's this guide that was out on the main table, which it's a guide to opportunities of all kinds of pro bono in Chicago. So that's available for your use. Also this week, as part of Pro Bono Week, I want to highlight that on Thursday evening at Jenner and Block from 5 to 7, there's a pro bono fair, where most of the pro bono agencies in Chicago that have volunteer opportunities will be and can give you information about those opportunities. There's flyers also out on the table if you're interested. Another item that you may have received is this clearinghouse review, which was generously donated by the Shriver Center on Poverty Law. And this particular issue is on legal recourse for people with disabilities. And inside the issue should be a flyer that shows you how to sign up for the Clearinghouse Review, which is a really useful resource. I think that there's another issue out that's specifically on the elderly with disabilities. So Ilza from the Shriver Center is here if anybody has any questions on the Clearinghouse Review or the work that they're doing. A couple logistical points. The session today will be 3 hours. There'll be a break at about the halfway point. Just a reminder to turn off your cell phones or pagers so we don't disrupt the session. And Illinois Legal Aid Online is webcasting this session, so if you wanted to go back and see it later, it will be available there. Also in the materials you received is a critique form. It's sort of cream colored. Looks like this. We'd really, really appreciate your feedback on these sessions. It's the best way that we can get information about what's useful to you. And finally, the bathrooms are just right out this main door to the right. The men's room is right here, and the women's room is a little bit further down the hall across from the registration table. So with that, I will turn it over to our distinguished panel, and I think Peter will be leading off and doing introductions. Thanks.
Thank you, Kelly. I want to make sure everybody can hear me. Can you hear me? Can you hear me now? Yeah, okay. Thank you for coming to this presentation on guardian ad litem practice in Cook County probate. This is going to cover adult guardian ad litem, adult disabled guardian ad litem practice. And I want to thank the CBA and the CBF for supporting legal services and pro bono and providing us this forum during Pro Bono Week. I also want to thank the panelists, not just for today, but for the last 14 years, because I have used them. They've been kind of my role models and my mentors for the last 14 years. Since I've been practicing, I've done adult guardianship cases, not always as GAL, but I've looked to them to offer me advice. Obviously, Judge, you can't give me advice from the bench, but you are a role model nevertheless. So thank you all for the past service and hopefully continued service through CVLS. My name is Peter Ashmore. I'm the managing attorney at CVLS, Chicago Volunteer Legal Services Foundation. I've been there for 14 years, practicing in various fields. I think I always come back to probate and particularly guardianship practice. That's what I like to do probably the most. And thanks to a grant from the Chicago Bar Foundation, CVLS last May took over the administrative responsibilities for the probate pro bono GAL panel that was started some years ago by Judge Connors and members of the CBA and CBF. So I enjoy that work as well, and it was kind of a natural progression for me in my practice at CVLS, and I'm enjoying it. You've got several materials in front of you, and in one packet is a sign-up sheet so that you, if you choose to after today, if you still are interested after the presentation, you may sign up and become one of the panel members. And I'll talk to you a little bit more about how you would get involved a little later. But the first thing to do would be to sign up and indicate your willingness to be part of the panel. GAL work is quite diverse. The issues are vast in number and vary quite a bit in complexity, from fairly simple to extraordinarily complex. But I think that if you volunteer as a GAL, you'll rest assured that you are doing something good and serving justice overall. It's really kind of a feel-good opportunity. I'm going to give you a little bit of an overview of today's program. I'm going to just do some introductory remarks about GAL practice. I recognize some of the faces out there, and some of it may be rather fundamental, but if you can bear with us, I think it'll get more interesting as, as all the other panelists speak. But after I speak, Eve Epstein will be discussing objectives and duties of GAL and the first interface with the respondent. The respondent is the alleged disabled adult, or the ward, I suppose, if an adjudication of disability has already taken place. And Eve will talk about those things and all of the duties of the GAL incumbent with that. Susan Kennedy will speak on reading medical charts and nursing home records, all of which can be rather daunting for the uninitiated GAL. And let me take a poll right now. How many have not taken a GAL case or never been appointed as a GAL in probate? Excellent. And how many have? And how many of you have taken more than 5 cases? Great. So this might be perfect. After Susan presents, Joe Piper is going to talk a little bit about creating the written report, which is a requirement. Not only does the GAL do lots of investigating and lots of talking to people, but ultimately a written report is presented to the court and filed with the court and is made part of the record. We'll have a short break, and then after the break, we're going to come back. Most of us will be in costume, and we're going to do a mock presentation of a GAL report, which might be really fun or embarrassing, depending on which way you look at it. But and then finally, Judge Connors is going to give the all-important view from the bench and some tips to practitioners in practicing in Cook County. So what is a GAL, or what do GALs do? Well, they serve the best interests of adults who are alleged to be disabled or who have been adjudicated disabled and are faced with issues that require a GAL's investigation. These range from the initial adjudication, does this person need a guardian, do they agree to the guardianship, and range in varying degrees after adjudication. It could be an investigation to whether a change in placement, a residential placement, is in someone's best interest. Could be to investigate whether a citation to remove a guardian is necessary. There are so many instances where a GAL is appointed. I think primarily today we're going to be discussing that initial appointment of a GAL to investigate the initial adjudication. When we throw terms around, we're going to use probably respondent to refer to the alleged disabled adult. Occasionally you might hear ward. Usually that's something they use when the individual has already been adjudicated. So guardianship cases handled by a pro bono GAL typically involves a developmentally disabled or mentally ill adult living with family in the community or in a group home. It may also involve a physically and mentally handicapped adult confined to a nursing home. Most often, a parent or adult relative has petitioned the court to become the guardian of the adult in order to make day-to-day decisions and consent to medical treatments and those kinds of things. Occasionally, when a family member is not available or able to be appointed as the guardian, a state agency or county agency will step in, and Office of the State Guardian or Office of the Public Guardian are the folks you'll hear about in that regard. The GAL has at least 2 important missions. One is to go out and meet the respondent. Guardianship takes away that person's most fundamental rights, and it's important for the GAL to try to communicate this and also to try to communicate ways that the adult respondent can protect those rights. the GAL's second mission is to act as the eyes and the ears of the court. Judge Connors is far too busy and important to go out and meet with all of the individuals on her call, but it would be physically impossible for her to do so as well. So she appoints GALs to go out and come back and tell her exactly what their situation is at home or in the nursing home. Is it appropriate? Is it safe? And to make a report on that. If the respondent is able to communicate, it's also a good time to find out about the respondent's wishes vis-a-vis the guardianship. In fact, the judge will always ask, does this person object to guardianship? Do they object to the petitioner acting as guardian? So you'll want to ask that as well, and I know that Eve is going to touch on that. It's interesting though, most GALs and most volunteers that I deal with at CVLS really enjoy the interaction with the respondent. Most anyway, and most of the time. Sometimes not, and maybe Joe can talk about that a little bit later as well. We've got a story there. But I think that the respondents enjoy it also. They enjoy the interaction with someone who is genuinely concerned with their health and welfare and care, and it can be kind of a compassionate type of thing, and cathartic maybe for both GAL and respondent in that situation. GAL's investigation also includes talking with caretakers, whether those are family members or professional staff at nursing homes or hospitals. In general, a GAL has to gather all the information possible to provide an accurate account of the respondent's life. And then finally, that GAL, as I mentioned before, would submit a report in writing to the court. Now, just a little bit about how you would get an appointment. And I'm going to talk generally about how you would get that appointment through the pro bono GAL panel. But it's fairly similar if you happen to be sitting in Judge Connors' courtroom and she looks over her glasses and says, "You, I want you." So it'll be somewhat the same. But so what happens is with Chicago Volunteer Legal Services and the pro bono GAL panel, we get appointments directly from the bench. They don't call us first to say, do you have enough volunteers or do you have time? They appoint us in an order. It says on the order, CVLS is hereby appointed as guardian ad litem, and the return date is, and it might be 2 weeks from that date, it might be a month from that date, but that order is faxed to me. I direct the program, and so I'm dealing with all these documents and the volunteers one-on-one, along with the petition, and you should have a sample petition in your materials, and an Exhibit A, if one exists. The Exhibit A lists all of the adult relatives that are entitled to notice, and usually that's it. So that's what we have, and so what I will do is I will call a volunteer, and I'll say, look, I've got this case, it's returnable on November the 12th, are you able to take it? A couple of things to keep in mind as a potential GAL are conflicts. Do I have a conflict with any of the parties in this case? And your schedule. Can you make that return date? Can you go out, meet with the respondent, investigate, talk to people, create a written report, and get back before Judge Connors by November 12th to present that? So those are the two most important things. Occasionally we only have an order. In some instances we are appointed after the adjudication to investigate those items that I talked about earlier, such as a change of residential placement, and so we'll have an order from a judge saying, please investigate change in residential placement. And so we'll have to do a little background and find out who the parties are by checking the court file. The items that you do get, the pleadings that you do get when we have the petition are important, and that's going to kind of set forth your first steps. It's going to list the names of the parties, obviously, but it's also going to list the name of the petitioner and their telephone or address, or their counsel's name, telephone, and address. And that's one of the first things that you want to do, is reach out to the petitioner or the petitioner's counsel to introduce yourself as GAL. It doesn't hurt sometimes by saying that you're doing it pro bono through CVLS. and ask for the doctor's report, which I know the folks up here are going to talk about later. But that's an important item. And you've got a sample of a blank doctor's report in your material. But the doctor's report is the first thing that you're really going to need. The petition will list a diagnosis or sometimes just a layperson's opinion about what's wrong with the respondent. But the doctor's report is the official diagnosis from the physician, an MD, that you're going to need as well. It's also, the petition will also state the location of the respondent, and obviously as GAL, you've got to meet with the respondent, and you're going to need to know where that respondent resides. Well, the first place to look is the petition. Sometimes it just lists a general name of a nursing home. I'm going to give you a website that I find really helpful in locating these nursing homes, finding phone numbers, and lots of other information about nursing homes, and that's abuse.com, abuse.com. When you go to that website, there's a menu on the left-hand side. You click on elder abuse on the left, and then you will click on Illinois on the next page, and it will take you to a fairly comprehensive list of Illinois nursing homes. I don't know that I have yet found a nursing home missing, if that makes sense. All of the nursing homes that I'm dealing with that I need contact information about have been on this website, and like I said, there's lots of other information on that website that you might find really interesting. So you've called the petitioner or the attorney. If it's the attorney, hopefully you've gotten permission to talk to the petitioner to get a general family history and background on the petitioner, what that petitioner's involvement with the respondent has been like, and what that petitioner's knowledge of the respondent's needs are, because that's ultimately going to go to your opinion as GAL about the appropriateness of this petitioner as the guardian. It's also important, and there's nowhere on the petition for the petitioner to affirmatively state, but it's important to ask if this petitioner has ever been convicted of a felony. Statutory that the petitioner has not been convicted of a felony, with some exceptions, but that's something that I always like to ask. There are also questions that you could ask about other family members' involvement. Hopefully you have an Exhibit A that lists all of the relatives, adult relatives of the respondent, but you could ask if anyone else is providing care or assistance, or if there's a power of attorney out there. Then you call the nursing home. Like I said, you'll get the number from maybe that website. Confirm that the respondent is there, is still living, and schedule a time to go out and meet. And it's always a good idea, before you get in the car, or maybe while you're in the car but not too far from your office, is to call again and confirm that they are still there. Lots of times individuals are discharged to other long-term healthcare facilities. They're hospitalized, they die. So you want to make sure before you make the long trip out that the individual is where you think they are. And finally, another thing as GAL that it's always a good idea to do is to check for some procedural issues. Has there been service on the respondent? Service has to take place before 14 days prior to the hearing date. Have all the people on Exhibit A been given notice by the petitioner? Is there a power of attorney? That person needs notice also. So these are just some of those issues that will be discussed as we go forward here. And that's hopefully an overview of what guardian ad litem practice involves and the initial steps that you would take. Again, I'll stay around afterwards. I'd also like to mention that if you have questions and answers, this is a very knowledgeable panel that you have, and it would be a good idea to go ahead and raise your hand during the presentations. Don't feel like you have to wait until the end. I think that most people up here are quick enough on their feet that they can answer your question, but I think also you'll find that the panelists will be chiming in as everybody's got a different experience up here, and everybody's got a story. So hopefully we can keep this fairly dynamic. Our first speaker is Eve Epstein. She's going to speak about the first interface with the respondent. Eve is an attorney with Epstein and Epstein. I'm not sure who that other Epstein is, though. She concentrates her practice in areas of adult guardianship, elder law, estate planning, probate and estate administration, and other matters impacting the lives of the elderly and adults with disabilities. She serves as a court-appointed GAL in the probate division and does volunteer as a CVLS volunteer in guardian ad litem cases. Prior to entering private practice in '86, Eve worked for 10 years in the Region 5 Office of the General Counsel of the United States Department of Health and Human Services as an assistant regional counsel representing the agency and supervising cases in matters arising in the areas of Medicare and Medicaid. That's also another area that we might have time to get into later. She is a graduate of Northwestern University Law School. She's a leading lawyer in elder law for the last 3 years. Her public service and advocacy is impressive, as is her involvement and participation with local bar associations. Here is Eve Epstein.
Thank you, Peter. I would like to say that I have done a number of CVLS cases as guardian ad litem, and I do find the work incredibly rewarding. So I encourage all of you, if at all you can find the time in your schedules and you are so inclined, that you try to serve as a pro bono GAL. It's a good thing to do. It's good for the people that you serve, and it's good for you in terms of what you learn in your practice. This is also an example of why it's good to go first and not second, because Peter already mentioned a lot of things that I was going to say. But I'll try to fill it in, and of course I'm happy to answer any questions that you may have. Peter's exactly right when he says that sometimes your appointment as a guardian ad litem comes when you're sitting in court waiting to be called on another case, and all of a sudden you hear your name and the judge asks you to come up to the bench and asks you if you would be willing to serve as a guardian ad litem, either in a pro bono capacity or otherwise. Other times, you may get a call from one of the clerks over at the probate court saying that the judge has just appointed you. Are you available to take this appointment? And sometimes you get the appointment in the mail as an order appointing you in a particular case. So now you've been appointed, and presumably you've decided that you're going to accept the case. And the question is, what is your mission, what are your duties and your responsibilities? The Probate Act itself, in 755 ILCS 5/11A-10, which I believe you have a copy of, provides that the court shall appoint a guardian ad litem to report to the court concerning the respondent's best interests. I think you could spend a lot of time doing research about what is meant by best interests, and that really changes depending on the case that you're involved in. No two cases are really ever the same. So it is left to the guardian ad litem to have some understanding, based on the information that you gather during the initial period and over your involvement in the case, to determine what you believe to be the best interests of the particular respondent. I'm going to limit what I'm talking about. I mean, I would be happy to answer questions where you're appointed, where there's a petition for temporary guardianship, and also where you're appointed after the initial petition and possibly after adjudication. As Peter mentioned, it's possible to be appointed if the respondent, or now the adjudicated board, has asked to be restored. The court may want a guardian ad litem to go and talk to the ward to determine if restoration is appropriate. And there are all other kinds of situations, but I'm going to at least focus on the situation where you're appointed just after the initial petition is filed with the court. It's your responsibility in determining the best interests of the respondent to make appropriate inquiries and assess information to determine these best interests. And you should know that the court really does care what you think and what you have to say. I don't think any of us have had an experience in a GAL case where the judge has not turned to us and asked us as a GAL, what is your opinion? What do you feel about this? Do you have any thoughts on this particular matter? So it's important that as you're going through the process and gathering information, that you have some ideas in your mind so that you can be responsive to the court when the court has questions, because they're really looking to you, as Peter said, the eyes and ears of the court, to provide some very, very basic information and assessments so that the matter can move forward. You have to gain the insight into the situation and determine, at least for the initial report, which, as Peter mentioned, pursuant to statute is to be in writing, what information should be provided to the court. Sometimes you'll have a respondent who's very chatty and wants to tell you all kinds of things, and it's really a question of you distilling down the information that you think is appropriate. You might keep it in your notes in your file, it might be handy at some other point, but you have to distill that information down. You actually, in the packet I think that was given to you, received some copies of GAL reports that I've filed in cases. I chose ones that were a little bit more involved and had nuances rather than very simplistic ones. But I think all GALs do it a little bit differently. There's no specific format or way that you have to do it, but you do have to provide the information that the statute sets forth, again, in 11A10, for you to provide. Your written report is usually presented on the initial return date on the petition for appointment of guardian, which is generally approximately 30 days after the filing of the petition. In cases where you have pro se petitioners, it's not uncommon that the GAL will be the person really helping to move things forward. Because quite often, pro se petitioners don't know that they need a CCP 211, or they have the form, they're not exactly sure how they're supposed to go about getting this filled out, what it is that they need, do they need an original, when do they have to have it back. The pro se petitioner will rely on the GAL a lot, and I think that the court will rely on the GAL to also help to move the matter forward. The Probate Act itself gives you some guidance as to your responsibilities, the areas into which you should be inquiring, and the information that you should provide in your written report. That statutory provision, which is entitled Procedures Preliminary to Hearing, which is again the 11A10, specifies that you are to personally observe the respondent prior to the hearing. That means that you have to go to see the respondent. If the respondent is living in their home, if they're living in the home of a relative or a friend, if they're in a nursing home, if they're in a hospital, wherever it is, you have to go to see that person. And that sometimes can be quite challenging. I had a situation where I was appointed in a matter, and I was following the respondent from psychiatric unit to psychiatric unit because he would be there for a few days, then he would be discharged, he had no particular address, then he was in the next psych unit. So it was a bit of a challenge to catch up with this particular gentleman and to speak with him. One of the things that you should bear in mind is, particularly with respect to mental health facilities, psychiatric units in particular, the entree to those facilities can sometimes be difficult. And it behooves you in advance to contact either the physician or somebody in that facility to explain to them who you are. I suggest that you offer to fax over your order of appointment and any other information that they feel they might need in order to allow you to come into the psychiatric facility to interview this person and to talk to them. It can be pretty challenging sometimes. The other thing that you are supposed to do, other than observing the respondent, is to inform the respondent orally and in writing of the content of the petition and of his rights under section 11A11, and I think you also have that in your packet. I provide that to the respondents in a document that I call Statement of the Guardian Ad Litem to Respondent. And even if you believe that the respondent can't follow what you're saying, can't understand what you're saying, as part of your meeting with the respondent, you must provide the statement of rights orally and in writing, including a situation where the person is lying in the hospital bed and apparently not responding to you. What you might want to do, well, I always give the statement to the respondent. Sometimes people don't want to take it. And sometimes if you say to them, I'm going to leave this with you, they tell you, no, I don't want you to leave that or whatever. I always leave a copy of that statement, which I sign with the date that I've been there. I leave it in their bedside table or on the bedside table, on their bed, some obvious place. If they then want to put it into the garbage or whatever else it is that they want to do with that, that's their business. But I've taken care of discharging my responsibility by providing them with that information. Attached to that statement is a copy of the petition, which I also explain to them, telling them that this petition has been filed, that this person is asking that you be adjudicated a disabled person, and this is who they are asking be your guardian. You can actually learn a lot by the way in which the respondent responds to your statement of rights and talking to them about their rights. It's interesting to see when people can actually read along with you, when they're holding it and they're actually reading, when they ask you pertinent questions, or if they're obviously not following it at all. That gives you some insight into what their abilities are in terms of can they read, can they ask you pertinent questions. You're also charged with eliciting information from the respondent regarding the actual adjudication of disability, the proposed guardian, change in residential placements, changes in care, and then that sort of garbage can category and other areas of inquiry deemed appropriate by the court. So the judge may ask you to inquire into certain specific areas if the court has certain specific information, but generally that leaves it open for you to enter into those areas that you uncover and determine are appropriate. Yeah.
From my experience, I have a question as to whether you want to have that a one-on-one, because quite often there's a relative present who influences the ward very seriously on any matter that's an issue.
Right.
Is there anything that speaks to the question of whether it should be an interview solely with the ward?
I think, well, what I do is, unless it's absolutely impossible, unless it's going to cause some kind of tremendous turmoil, I ask for family members and friends and other people to please leave the room, that I want to be alone with the respondent to speak to them. Now, sometimes that's very difficult. I don't want to create a brawl. That's not the point. But I do routinely ask that people please leave the room so that I can speak with the person alone. And I do think that there are situations where that just can't possibly happen. I mean, where the person is so nervous or so anxious that perhaps it would harm them to have people leaving. But I do ask that if anybody stays in the room, that they absolutely not say anything. And I also try to position them in a way that they're not answering the questions. It's not always so easy.
There's no rules or regulations.
There's no rule that specifically says no. No, but I kind of try to throw my weight around and say, look, I'm the eyes and ears of the court, and I'm reporting back to the court, and I'm going to want to tell the court that I met with the respondent individually, and if I have to say that you wouldn't leave the room, that kind of thing. But there are occasions where people just simply will not leave, and you just have to deal with that as best you can. I do think that it's appropriate to interview the person at least for a portion of the time individually with nobody else present.
Joe Piper. Sometimes actually you might want a family member there. It really depends on the situation. You know, you will get sometimes a pretty good feel if there's any undue influence going on at the time, or you'll find out beforehand because part of your investigation is to talk to the petitioner, well, at least the petitioner's attorney, to see what's going on. And a lot of times the petitioner's attorney is going to tell you that there's something unusual going on. One of my questions always is there anything unusual about this case that I should know about before I go out to see the petitioner? One of the reasons sometimes I would like somebody around is, and you have to be careful because they tend to want to coach them, and that's not what you want them to do when you're asking orientation questions. But if it's, let's say, a vanilla type envelope kind of case where there's no undue influence, but you've been told that the respondent may or may not object, but that the individual, say it's a son or a daughter, is vying for guardianship, and at least initially in your view, there isn't any undue influence going on. Well, if you go out there alone and you ask the individual these questions, and one of the most important questions is whether or not they're objecting to guardianship, and this person being the guardian, you may get an objection because they don't remember who the heck this person is. Whereas if they're sitting in front of you and you know this person is trying to do the right thing, you're not going to catch an objection. But I always ask in those situations first whether or not it's okay for this person to be present when I'm interviewing the respondent. But then there's situations where you want, one of my examples is a situation where I walked into the house and one of the people who was supposedly unduly influencing the person was sitting there right at the kitchen table at the time. I'll discuss that when it's my turn. But anyway, it's a case-by-case basis, and that's the thing about GAO work, is you have to get kind of a sense of what's going on, because you can't, it's not a cookie-cutter kind of thing, you know. You have to kind of figure out what's going on at the beginning and try to get up to speed as quickly as you can, even before you talk to the respondent, because there are certain things you may not know beforehand, and so you're going to approach that a little bit differently. Sorry.
I think that's just a good example of the fact that people approach these things differently, and each case really is very different. I mean, you're dealing with human beings in extreme circumstances quite often, and there's really no predicting how these things shake themselves out. Sometimes you have an idea of what things are going to be like when you walk in, and it turns out not to be that way at all. One important thing is that, of course, guardian ad litem, just the term, is confusing to people. And when you try to explain who you are and what your duties are, you might explain, well, I'm an attorney. Well, then the question comes up, well, are you my attorney? I think it's very important to explain to people, guardian ad litem does not mean that I am your guardian, or that I am making decisions about you or for you. And the fact that I'm an attorney does not mean that I am your attorney. So you should understand that when you're talking to me, what you tell me is not confidential. Sometimes people get it, sometimes they don't. You'll get some feedback and somebody will call the office because on my statement I put my address and telephone number so people can call me. I usually leave them with my card, and they'll call and they'll say, well, you're my attorney, right? So, but I do think that it's important to tell people that you are not the attorney and there is no attorney-client privilege. Also, sometimes you have to clarify the role of a GAL for personnel in various facilities, including hospitals and nursing homes and group homes. When they see the word guardian ad litem, or they get the order appointing you as the guardian ad litem, it's not at all uncommon to get a telephone call some weeks later saying, you know, Johnny needs to go to the dentist. Is that okay with you? And you have to explain to them that I'm the guardian ad litem, I'm not the guardian, this is where we are in the proceeding. So usually, you know, depending on who you're dealing with, you can get some sense of the information that you need to provide to them, to explain to them what your role is. As an initial matter in preparing for meeting with the respondent, I always call the petitioner's attorney, I introduce myself, I ask for an overview of the matter, I get any pertinent information from them, I ask them to please fax me any information that they might have, any documents, medical reports, financial statements, anything like that, that they might be able to provide. But I also bear in mind that as the petitioner's attorney, they are seeing these things from one perspective. I also get names and contact information for all the interested persons, those people listed on Exhibit A, anybody else who might be out there, doctors, financial advisors, any other attorneys that might have been involved in estate planning. And I usually make a general statement saying, I'm going to be contacting your client to discuss this matter. It would be helpful to me if you would please call them to let them know that I'll be calling, what my role is, and generally what I'm going to be looking for. And that can be very helpful. That way you're not making a cold call to somebody and just saying, hello, I'm the guardian ad litem. And also they might do that for family members. Yes? A person in Illinois is...
Yeah, can you repeat
Repeat the question.
Oh, the question was, during this period of time, and I'm assuming that you mean from the time of the filing of the petition until an actual adjudication. The state of the law in Illinois is that a person is presumed to be competent until the point at which they are adjudicated to be disabled. So while a petition is pending, a person is presumed to be competent. Now, if there are problems, it could be that the petitioner is going to come in on a temporary guardianship, in which case a temporary guardian might be appointed, and that temporary guardian will be given certain authority, which has to be specifically delineated in the temporary guardianship order. So that's a hybrid. But during that period of time, there is no, the person himself, herself is her own decision maker. I would be wary of situations where somebody wants to do estate planning while there's a petition for adjudication pending. But that's not to say that that doesn't happen. And that's something that a GAL may have to look into.
What about the Healthcare Surrogate Act, and how does that play into decision-making prior to guardianship?
Well, I assume that many of you are aware of the Healthcare Surrogate Act. It provides under the situation where the individual is no longer able to make decisions for themselves in healthcare matters, and there's a list of persons who can make decisions in the order of priority, and that would continue in effect during the pendency of the petition, unless for some reason there were an order of the court suggesting that that shouldn't happen, or there were a temporary guardian who was given the authority to make those decisions. And that's quite often one of the provisions in a temporary guardianship, is that it would say that the temporary guardian has the authority to act under the Healthcare Surrogate Act for routine medical care. Yes?
I apologize, but I have a question, procedural question that is not, I'm used to a different system. And I don't understand, how are you getting past, you're an attorney, but you're contacting someone who may or may not be represented. If they are represented, how are you dealing with that? And how does the ethics rule here of the bar handle that?
You mean in terms of your contacting the respondent?
Well, possibly if the respondent has an attorney already, or if the petitioner has an attorney and does not want them contacted?
Did you want to repeat
Yeah.
the question?
Yeah, I can repeat the question. The question is, you're an attorney, you're gonna contact somebody as the GAL, and, the question is, if that person is, represented, and you know well, you may or may not know, that, the attorney doesn't wanna, represent him, you contacting him, but I guess that's not the issue. The issue is that you're an attorney trying to contact somebody else who's represented. Well, we know that, under our guidelines, we can't do that. But you have to understand, we're not, and this is what I think Eve was trying to point out. We are not acting as attorneys when we are appointed as a guardian ad litem. We are guardian ad litem. I had exactly that case where there was I'll just say it, obstreperous attorney that I personally, as a guardian ad litem, didn't think was representing the person's best interest, and I went out and interviewed the GAL, without advising his attorney that I was doing that. And I was well within my rights as a guardian ad litem. I had a court order saying that's what I was supposed to do.
Right. I think if you look at the statute specifically, it actually says that you don't have to be an attorney to be appointed as a guardian ad litem.
Right.
I just think it's important that, for example, when I leave my card with somebody, it says that I'm an attorney, and I think it's important that I identify myself, but make it clear that I'm not functioning as their attorney. So I think that's part of the process. I would suggest that any of you who are going to do guardian ad litem work, or who are going to appear in the probate division, notwithstanding the fact that I've been doing this for a fair number of years, it never hurts to read the Probate Act, because I find that no matter how many times I go back and read provisions and reread them, I always find something that's interesting. And the Probate Act, I think among all the acts, in the Illinois law, is pretty clear in terms of how the process works and what it is that you're supposed to be doing, and it's pretty much all spelled out there. So I urge you all, if you're going to be doing probate work, to read the statute, and obviously if you're going to do GAL work, to read the statutes that are relevant to the GALs.
Can I just add for a minute? You're absolutely right in citing the statute. We do not have to appoint attorneys as guardian ad litems. As a matter of practice in Cook County, we do. We feel it's very important that we have an attorney serve as a guardian ad litem, because you're reading rights to somebody. And they might ask you, explain that to me. What does that mean? You're giving them what their legal rights are when you're serving as a guardian ad litem. So as a practice, we, for the most part, usually 99% of the times, it's a lawyer that's a guardian ad litem. Doesn't have to be. I have appointed social workers as guardian ad litems and other people, but as a practice, we usually don't.
I'd also just like to add that, when I teach my students at DePaul, I say, roll back to our U.S. Constitution. We have the due process right that's fundamental. And really what the GAL is doing is carrying out that concept in as much as, okay, they're being served summons through another whole system, but this person may be in a bed, unable to move from the bed. If you're in a car accident, you get served summons, you're going to find a way into court. This person isn't maybe even going to understand what that summons means. So we serve sort of a strange role, but it really carries out the due process element from the Constitution.
One of the things that you should bear in mind, because you are charged with observing the respondent personally, is, and since you're going to be going into homes and various neighborhoods, is to check ahead of time where it is that you're going. Some neighborhoods you might not want to be in late at night. You might want to make other arrangements to meet. I've actually met people at Starbucks and places like that if they're able to do that. And they might feel more comfortable about that, although I like to see the environment that they're living in. But you should be aware of that when you're making your arrangements to go to see the respondent and any other family members. You should also determine, as part of your investigation, whether there are existing powers of attorney. And it's one thing to determine if the person has executed powers of attorney. You should determine that. If you can see them, that's a good thing. and determine if anybody has been acting pursuant to those powers of attorney. Quite often, you will find that somebody's been acting pursuant to a power of attorney. There are questions about what they've been doing. And it also puts them in a unique position because they're a fiduciary and they have fiduciary responsibilities with respect to that person. So one of the assessments that you're going to want to do is to understand what the interface has been between the respondent, the family, and the agent pursuant to the power of attorney. Quite often, there will be a petition filed to revoke powers of attorney, or an individual may be asked to step back, resign from the powers of attorney. So powers of attorney come into play in various ways. Most importantly is that the circuit court will not appoint a guardian if there are existing powers of attorney and there's no abuse and the respondent is not complaining, because there's somebody out there to do that work. So it's important to know whether in fact there are powers of attorney that are out there. Quite often you will find that there are several. You might find situations where a power of attorney has been obtained under duress or fraudulently. It's very important to inform the court whether there's a power of attorney. Yes?
Is the existence of powers of attorney that are being exercised grounds for a motion to dismiss a petition?
I can't hear you, Julie.
Just
Okay.
restate the question.
Yeah, I can the question is, if there are existing POAs, powers of attorney out there, is that grounds for a motion to dismiss the petition?
I don't think it's prima facie grounds, because I think that you have to investigate what's going on behind the powers of attorney and how they're being exercised. If the respondent is in a position to control the powers of attorney, you know, if you look in the statute and you talk about revocations of powers of attorney, there's a question of whether the principal can control the actions of the agent or has the wherewithal to revoke them. Those are relevant questions in terms of them existing out there. But I don't think that it's prima facie that once you have, just because you have powers of attorney, that you can come in to dismiss it. Not once you have a pending petition. That's my opinion. I think that you should bear in mind when you're going out to see a respondent that you are quite often the first person who's going to see them and let them know that a petition for guardianship has been filed, that somebody has been asked the court to adjudicate them to be a disabled person. Needless to say, that can be greeted with a variety of emotions. I mean, quite often people are angry. They don't understand why this is happening. Why is this person doing this to me? Frequent question I get is, what did I do wrong? I've never had to go to court before. Why do I have to go to court? They might be very frightened, or they simply may be unable to understand. You should be prepared for any and all of these responses, which sometimes can make the job quite difficult. You should be prepared to speak with people who are physically ill, who are demented, who are mentally ill, and notwithstanding all of these difficulties, you should also remember your mission, your duties and your responsibilities to the court, and use your skills to provide the required information to the respondent and to get as much pertinent information back from the respondent. I also, because there's an issue of the respondent being present on the return day, I always ask the respondent if they want to be present, and if they say, well, I want to go, but I don't know how I would get there, or I have some difficulty, no matter where they are, if they're in a hospital, a nursing home, or at home, I say to them, if I can make arrangements for you to be present, which I will do you want to be there? And quite often when people realize that somebody's going to arrange for them, if they're in a nursing home, they're going to be accompanied in a cab, or somehow they're going to get there, they want to be there. In your report, you should say to the court whether you believe that the presence of the respondent should be waived, and there are specific reasons when it can be waived, because you think it would be harmful to the person to be there. So it's important that you ask the person, because if they're living alone or they're in a nursing home or wherever, if they're in a nursing home, I usually go to the nursing staff and tell them that the person wants to be present. Would they please make arrangements? I follow up by calling to make sure that they've done that. Simple observation is really the key, I think, to being a successful guardian ad litem. How is the person dressed? Are they dressed appropriately? What does their home look like? What does the environment look like that they're in? And similar sorts of inquiries, and I try to include that information. I think most GALs do. Person was appropriately dressed, the home was cluttered, you couldn't walk, you couldn't sit down, whatever it is. You will also, over time, develop techniques for eliciting information. One of the things that I do that I found particularly helpful is I always put some change in my pocket, and when I'm talking to the person and asking them basic information like their birth date and members of their family and their address and what their occupation was and where they worked and all of those basic sort of things, the date, the season, do they know who the president is, do they know who the mayor is? They often know the mayor and not the president. I take out these coins and ask them to identify each of them. It's a quarter, it's a dime, how much is it worth? And then I ask them something very basic, like if you were going to the store and you bought something for 35 cents, which of these coins would you use? And obviously some people can answer that very easily, and some people can't answer it at all, which gives you a pretty good insight into what their abilities are, and it's just a very small thing that you can do. It's also not threatening. Most people, if they think it's silly, they'll do it anyway. In conclusion, no matter how many GAL appointments you do receive or how many guardianship cases you're involved in, no two are ever really exactly alike because of the human factor, because of the people that are involved. And your success as a GAL depends on your ability to communicate, to observe, review, understand, and process the information, and to provide a good report to the court. Now, it's possible that after you report to the court on the return date, if there's an adjudication of disability at that time, you might be discharged. It's possible that you will continue on in the case as the GAL for a considerable period of time, and that your duties will change depending on how the situation changes. Any questions? Ms. Fox.
I just wanted to offer one little hint that I have found very helpful. When you go to see someone in the hospital, sometimes English isn't their first language. If it's Spanish or Polish or Russian, it's often very easy to just walk outside and say, please find me someone on the staff who can come in with me. Because it may not be that they don't understand what you're telling them, they may not understand it in English. And so if you bring a nurse or an aide or someone else in who can speak to them, it's
Right.
very helpful so that you can at least know what they're saying to you.
Right, that's a good point, and actually that may control when it is that you're going to see somebody in a hospital, because quite often there are not as many interpreters or people around during the evening, so you might want to make sure that you would go during the day, so that if there's an interpreter available during the day, that you can utilize the services of the interpreter. Yes?
One other little tip in terms of that discharge. If you are discharged, you should always try to be discharged in writing on the order, either separate or on the order that the person has there, because you don't want to be in a situation, as has happened to me a couple of times, where you're discharged orally, but then later on, several years later, you get something in the mail saying that there's a foreclosure notice and you're a party to the foreclosure because you're the guardian ad litem.
Right, right.
So things of that sort, unless you want to be involved with this, even when you're not involved with it, you should definitely be getting it in writing.
Right, and you should also understand that sometimes when you're discharged, the judge may say, well, I'm discharging you now, but I may want to call you back into the case at a later date. Yeah.
I wasn't
must be in a vacuum here, I can't hear.
The question was, it wasn't clear whether, who should assist the respondent to court if they want to come to court.
You know, I've found that in nursing homes, if you talk to the nursing staff and tell them that the person this is the time and this is the date when they should be in court, will they please make arrangements that they can do that? And they will do that. Hospitals will also do it. Quite often, they'll transport the person by ambulance. So it's something that you may want to consider, how you want to set it up. You know, if there are family members who might be able to transport the person or somebody that they trust to transport them, you might want to do it that way because the ambulance can be quite costly. And then, they wait around and they bring the person in on a gurney, which sometimes can be a problem for people. But there are ways to make arrangements for them. Yeah.
If I make in my report, as GAL, if I say that such and such nursing home, I don't believe that she is doing a good job, am I liable now to sue?
If you say that the nursing home is not doing a good job,
That's what I really think. I just think that maybe the now, is there anything in the statute or anywhere that says that I'm sort of trying to say that without pursuit?
well, I mean, the truth is always a defense.
It's within a lawsuit.
So,
Why don't you phrase it, I'm concerned about the care, Judge, of the nursing home, instead of coming to some conclusion.
right.
Well, no, I understand that. I know you're right that, but I wonder, is there anything that needs to be protected? If I don't write it the proper way.
Well, I mean, I usually try to
Can you repeat what he
do
said?
it as something, the question was really about the liability of the GAL for writing something in their report. For example, that a nursing home is not doing a good job. I try to cast it in terms of the facility is not meeting the person's needs, and this is why.
But there's nothing that's gonna protect me.
We have malpractice insurance.
No, I mean, we've actually, and I probably shouldn't tell you this, but there actually have been GALs who have been sued in various cases. I don't know on a liability based on something that they've had in a report.
I've never heard of that.
No,
Never.
if you say it's my
14 years.
opinion and you don't make a conclusion that they are doing a bad job, I can't see how you're gonna get sued. Besides, it's within a lawsuit.
People get sued all the time.
Well,
Well, then
that's
don't
true.
make
Or
them
if, or if you state it in such a way that it's a factual thing, like on the day that you went there, the nursing home smelled. If the nursing home smelled on that day, the nursing home smelled on that day. I mean, if there was dirt on the floor, then there's dirt on the floor.
I mean, I sometimes go to the Illinois Department of Public Health website, I'll print out the most recent survey, I'll bring that into the judge, I'll say, look, this is a place that has had problems over time. I mean, I've never felt inhibited about bringing that information to the court.
And let me just interject also, I haven't been doing this as long as the other folks up here. I've never seen that happen, and if you volunteer through Chicago Volunteer Legal Services, you're covered by our professional liability insurance.
That's what I wanted to do.
But the other point is that as a GAL, you often step into the breach. There's no other way to say it. I mean, you're there, you may be the only person between, you're the gatekeeper sometimes. You may be the only person between the individual really being in financially or physically abused and not. So sometimes you have to make those decisions.
I mean, these cases over time, I find, are becoming less and less vanilla. I mean, I don't know why that is, but I think Peter would agree that it's very rare that you just have a case where, you go in, you see the person in the nursing home, you interview them, they say, okay, it's fine that my daughter is my guardian, you've got a CCP 211 that says that they're demented and they can't handle their own affairs and they're adjudicated on the return date, you're discharged and everybody goes home. That's not to say that they're not out there. They are, but I think it occurs less and less now, and maybe it's just because the volume is up of these kinds of cases because people are growing older, and there are more older people and more people that are living with dementia and mental illness and all of that. But I've never had that problem. So, and I've done a lot of reports where I put information about people. I am careful when in my initial report, if I'm talking about financial exploitation or potential financial exploitation, to say, you know, it appears that this has happened. And actually, the case that we're going to talk about later, which is in your packet, the estate of RR, there were allegations of financial exploitation. So, yeah.
I have a question regarding working with the healthcare providers at the nursing homes. I found that one of the most important things to know when someone is petitioning to become a guardian is, you know, whether they've been visiting consistently and who else visits. And sometimes it's hard to find out because the person hasn't been there very long, and sometimes the case arises because the person has been moved and the family members aren't happy about that. In those situations, is it appropriate to contact prior nursing homes, and do those facilities have an obligation to work with you, or can they legitimately say, oh, that person's not here anymore, you know, we don't have anything to do with it?
I mean, I think that whatever avenues you think are appropriate to get the information that you think is relevant to the best interests of the respondent, which is your charge, is something that you can pursue. Whether you're going to come up against a dead end or people that are not going to be responsive, or they said they'll get back to you, that happens. But I do think that it's important, you know, when you're at the nursing homes and you're at the hospitals, that you look at the charts, that you look at all the information. Susan is going to be talking about how you review those charts and the information that's in there, and that you try to talk to the personnel in these facilities to get some idea, you know, what is this person doing? Can they perform activities of daily living? How much assistance are you giving them? That sort of thing. Asking the respondent themselves, what type of medication do you take? What, you know, who is your physician? It's always very telling if you walk into the house and they have in the kitchen, you know, bottles and bottles of medication, and they can't tell you what medications they're taking, and they can't tell you who their doctors are. Those are problems. That gives you some idea of areas where the person might not be functioning as independently as they should be. So.
Do you have any problem regarding medical records with regards to HIPAA laws?
Usually with the order appointing, you get access. Now you might have problems with mental health records in some of the mental health facilities, and actually I sometimes go back to the appointing judge and draw an additional order saying that notwithstanding HIPAA, I have the right to review these and that they should release it to me and what have you. And then with a specific order, they feel more confident about doing that. I also suggest that you fax those orders over during the day, because if you go at night and you have a night staff and they don't know who you are and they haven't seen anything and the DON, the director of nursing, isn't there, they may be hesitant to turn those things over. Of course, there's the other situation where you walk in and you just say, I want to see Ms. Jones' file, and they just hand it to you. So, you know, it goes both ways. Anyway, I'm going to turn it over to Susan, who's going to, since we're talking about medical records, should we introduce?
Let me just say a couple words about Susan. She is not only a JD, but she's an RN, which makes her particularly suited for this topic. 13 years ago, I presented at the CBA on guardianship issues with Susan. We both felt, since we were only about a year or maybe 8 months out of law school, what are we doing here? But boy, she's come a long way. So thanks, Susan, and thank you, Susan Kennedy.
Thank you. Okay, you've just gone to see this woman in the hospital, and you've been able to elicit some of the information that Eve referred to, and you think you've got a better picture of who the respondent is. One of the things I think is really urgent is to be able to ask the very specific question, do you want a guardian? And you want that answer to be yes or no, or maybe, or I don't understand. And then the other question is, do you want whoever is the proposed guardian in the petition to be your guardian? And that's another very clear question with a very clear answer. But once you've gotten there, you're going to go back out to the nurse's station, and you're hopefully going to avoid any HIPAA interference, and a staff member will be able to say, oh, you know, family comes, family never comes, she's a very easy patient, she's not an easy patient, or he's been violent to somebody on the staff. I mean, these are the kinds of things that you're hoping you can just elicit just with staff members. Sometimes you'll find the staff doesn't know this person at all, and that's true even in nursing homes, sadly, but it's worth a query because you can glean some things that you might not find in the chart itself. You probably know that there are charts in nursing homes and there are charts in hospitals. How many people here have ever actually looked at a hospital chart itself? A lot of people. Well, then you know much of it is hard to read. And I can't interpret for some of those doctors' handwriting, but I can say that over time you develop some sense of what you're expecting to see, and you can extrapolate, or shall we say actually interpret the scribble. But nurses as a general rule have better writing. I can demonstrate myself, but I won't, I'll spare you. So sometimes I go straight to the nurse's notes because they're legible and you can read them and you can get a sense of what she was like at the beginning of the admission and what she was like at the time of your visit. But let me back up. I jumped ahead. So you're either looking at a chart in a nursing home or you're looking at a chart in a hospital. The charts generally are divided into certain parts, and you can see the tabs along the side. But for sort of general purposes, there are notes, there are orders, there are forms, and there are prescription records. So not that you have to really get intense about any one particular part, but if you understand that those are the general categories, you can then go, for example, to the notes. And as I say, I like to turn to the nurse's notes because I can rarely read the doctor's notes. But every so often you'll see a doctor's typed up note, which is very helpful. Consultations are usually typed. So those are easier to read, and you can assume that if a consultation is called in, there was a reason for that, and it's illustrative as to what's really going on from a medical point of view. Also in the notes section, you might have social worker notes. They can be informative, especially about background and how did, for example, was this person educated? Were they found by the Chicago police and brought into the hospital? I mean, you can get some sort of a different kind of history from a social worker note that can be very helpful. Also, therapy notes. If somebody is in because they were hit by a car and they're a Mary Doe or a John Doe, which could be a case that you would get as a pro bono GAL. There isn't much information, but you can find out from the therapy, for example, are they participating in any physical or occupational therapy? Those are the two forms of therapy that are most used. Well, speech therapy too, for someone who's had a stroke, can also be a useful source of information. I'm giving you this for a reason. I like to describe, again, to my students, that what they're doing, yes, they're the eyes and the ears of the court, of course, but you're also painting a picture. Judge Connors is not perhaps going to see Mary Stewart in that bed for the many reasons that she may not be coming to court. But if the judge reads the guardian ad litem report, the judge has a visual image of who this person is. And the more detail you can give, in my opinion, and again, as Eve said, there's a variation on the theme of what these GAL reports look like, but from my point of view, you're helping the court get a visual image of who this person is in that bed. And it is painting a picture. So the kind of information you get, you'll if you keep that concept in mind, rather than just flooding the report with your knowledge, you might just streamline it to be able to identify, okay, what is important for this judge to know? But in the meantime, you're looking at the record and formulating some sort of a hierarchy of information. The prescription record, or the medical sheets are important from a prescription point of view, because even though, I might understand what those meds are. By the way, I don't always anymore, because there's so many medications on the shelves now that I often am using my PDR. But that said, there's special sheets in the record that are lined up so that you can see the medication order. The judge isn't really interested in the milligrams that this person's getting, nor whether it's being given by mouth or by intramuscular injection. But what the judge might want to know is if this person's on a psychotropic medication, because that leads to another question. Why are they getting a sleeper at night, for example? What's the behavior that's contributing to that, the need for that particular medication? You might want to know whether they have a heart condition, not because you can read the doctor's report, but because you can see that they are on specific blood pressure medication, various kinds of cardiovascular medications. So the meds do help to get this medical image of what this person is, and again, with the intent of painting a picture for the judge. I have given you a set of medical terms. Many of you may know them. If you have, just throw it out, but I think sometimes it's useful for a new guardian ad litem to have some idea of what words they may need to try to look for in these medical charts. The first set of documents or the first set of terms are really the terms that may describe the status of an individual. They're self-explanatory, but they do, again, begin to help you as the guardian ad litem paint this picture for the judge. The next set of terms are very typical medical procedural terms. I think one of the very important things to look for is whether or not the chart, either at the nursing home or at the hospital, has a do not resuscitate order in it, and who signed that order. You probably know now there's a statutory form that identifies a do not resuscitate consent. But typically what we're talking about is whether or not a doctor has stated that this patient will not be resuscitated. But the doctor will state it based on a consent from the individual. So the forms are usually in sort of a greenish blue, and you may see that very often in a nursing home chart. You may not see it quite as often in the hospital charts. I think that there's a practice going on out there that as soon as somebody gets admitted to a nursing home, they're asked to sign one of these do not resuscitate. I mean, I know I'm exaggerating a little bit, but not very much. You know, you really do find these things more often than you think that you should in a nursing home. And it's important for the judge to know somebody out there has already made a decision about whether or not this person should be resuscitated if their heart stops or if they stop breathing. So the other terms are what they are. I think that abbreviations can be helpful because when you're looking at nurses' notes or doctor's notes, you will find them abbreviating. And these are not, I mean, these are literally used throughout the United States. These are not just local kind of abbreviations, and they can be helpful. I do want to mention two abbreviations that I forgot. One of them, we just referred to it as the HIPAA. You know, that stands for Health, what is it, Privacy, something Act. Anyway, it's about, yeah, exactly. Anyway, everybody knows it is HIPAA. It is the sort of stop for those of us who might want to be looking at a chart, but as has already been described, if you give them a forewarning during the day, usually you can get them to the chart without a problem. But believe me, I've had problems, so it's not always possible. Sometimes if you don't get through to the chart on your visit, you can call the social worker the next day during the daytime, and he or she can read you the pertinent parts of that chart. The other term I forgot to add is ADLs, Activities of Daily Living. I tell the story that when I was in nursing school back in the, anyway, a while ago, the term came up in school, and we all thought it was a nursing term, and I really do believe the origin was in nursing. But now it's very commonly heard in the courtrooms, and it is abbreviated as ADLs, Activities of Daily Living. So you can add that to your number and to your abbreviations there. Also, I've added abbreviations of certain medical conditions, you know, DM, diabetes mellitus. You see that really a lot as a GAL, because many times you're working with an elderly person who's had mature onset diabetes, and that term is abbreviated in their chart. I'm just going to quickly touch on Medicare, Medicaid. You know that these are separate, totally separate programs. Medicare has parts to it. I've described those there. Public aid is not, every person you go out to see will not necessarily be on public aid, but it will be helpful to know whether a public aid application has been filed for or whether they're already on public aid. We've talked about powers of attorney. Two important statutes that I think everybody in this room, whoever becomes a GAL, should look at are the Mental Health and Developmental Disability Code and the Mental Health Confidentiality Act. Both of those are relevant. If you have a respondent who has a mental health issue, these are really critical to understanding how you can approach the whole guardianship, because maybe the family is really seeking to have somebody committed, which, as you all probably know, it's not possible as a guardian to involuntarily commit your ward. You still have to go through the mental health proceeding. And then I've also added some websites there that would also be a resource for terminology and definition of disease processes. Done. Okay, thank you.
Thank you, Susan. Is this you?
Yeah, thanks.
Okay, we'll do one more presenter, then we'll have a break, and we'll come back for the mock presentation of the GAO report and Judge Connor's presentation. Our next speaker is Joe Piper. He's been practicing for about 20 years and concentrating in probate involving the administration and litigation of adult disabled estates, deceased estates, and minors estates. You can read his bio. He's a really smart guy. Joe Piper.
Used to be. Good afternoon. First of all, I just was wondering, did everybody get the handout with regard to my examples of report of GALs? Separate from...
That was the separate package. You've got one that was prepared by the Chicago Bar Association, and another stapled package with the volunteer sign-up sheet.
Okay.
And yours are in there.
Excellent. Because I didn't have enough to pass around, sorry. All right. My name's Joe Piper, and my segment is talking about now. Okay, so you've done your investigation. You've gone to the nursing home. You've gone to the hospital, or you've gone to the person's home. And this is why, I guess that's sort of a caveat. That's why you want to talk to everybody before you. Can everybody hear me? Sorry. Why you want to talk to people before you actually head out to talk to the person, because especially if they're living in a home, you want to make sure there's contact information. You at least have a phone number, so you're just not going out there and wasting your time. And I've actually had a situation when I was just starting out as a guardian at Litem. I went out all the way to 180th, or as far as Cook County goes. I didn't even realize it went that far. I went to a nursing home, and lo and behold, the person unfortunately passed away the week before. So it pays to call the nursing home, talk to the petitioner, and if you talk to the petitioner's attorney, say you might get this appointment 3 or 4 weeks prior to the return date. It may not be a temporary return. It's still really important for you to call the nursing home maybe the day or so before you actually go, because things happen. They may go to the hospital, they may have also passed away. All right, my topic is, okay, we've made the investigation, we have all the information we need to actually write the report, and as I think Eve and possibly, no.
Oh, sorry.
I was thinking, who else was talking? No, I did not forget your name, Susan. I do forget a lot of names, but anyway. My report is a little different than Eve's, for instance. I actually split mine up into different topic headings. I always have an interview of the respondent. I always have, if I actually am able to read the chart, and then conclusion, and interspersed in there, depending on the situation, I'll put added information in there. Just one minor note with regard to the chart. It's important to do what Susan and Eve said to do, but you know what? Sometimes you're just not going to get to see the chart. I had a situation, for instance, that I found out later. The reason I wasn't going to get to see the chart is because there was a medical mal pending, and they didn't want anybody to see that chart. And I actually waited 2 hours. That was the last time I did that. So if you're not going to get to see the chart, especially late at night, if it's a temporary, don't waste your time. Do the rest of your investigation, and probably you've given the court enough information, because you're probably going to have the CCP 211, which is the physician's report that we've talked about before. That's why it's important to get it actually before you actually go out and see it. So anyway, I've got 4 different reports. I'm going to discuss generally the way I organize the report, and then talk about these different 4 reports that actually involve different situations. The vanilla box type of situation is the LP report. It's the state of LP. These are actual people, but I made sure that I've redacted names and other references. Anyway, this is a situation where the poor person had an intracranial hemorrhage. What happened was this person used drugs, and it turns out this probably wasn't the first time this happened, but this is the first time it really landed her in the hospital big time. This was a situation where I was asked to go out actually that day and come back the next morning and report to the court what my findings were. So this was a temporary, and basically what the petitioner is trying to do is get temporary powers to be able to make routine medical decisions, and actually in this case make sure that the person got into rehab, because under the chart, and I'll talk about that in a second, this person under the chart indicated that they definitely were a rehab candidate, and so anyway they got in there. So the first thing I do is I have like a little introduction of who I am and how we got to this place, which is somebody filed a petition. Is there a temporary petition? Is there a plenary? So we know. Okay, so we got that. Then I go into the interview of the respondent. When I interviewed him, where I interviewed him, how did the respondent look? Were they disheveled? Did they unfortunately, did they smell? If they had a gangrenous foot, was it well wrapped up? All kinds of things like this. In this situation, this poor lady was being well taken care of by the Rush University Medical Center. She was, as I say, she was appeared neat and well kept in appearance. I actually happened to be there when she was eating dinner, so I could tell she was actually had a regular diet, which is important sometimes to know. I couldn't tell whether or not she was ambulatory because she was reclining in the bed the full time. Then I go into that I advise them of their rights under 11A11. As an organizational note, one of the things I also have, I think all the GALs have, is some kind of statement that we give to the respondent. In my case, I call it statement to the respondent. It has what's going on, who filed the petition, who appointed me, what generally they can expect if a guardian of the person and the estate is appointed, when the plenary date's going to be, which is the permanent date, and when maybe the temporary date's going to be, and then what their rights are under 11A11, which is the last paragraph. So I make sure that the court knows that I advise them under the rights under 11A11. I explain the rest of what my statement of rights is, And I always put, I've done this now for a number of years, I always put whether or not the individual is objecting, because usually, sometimes, especially if it's a vanilla box kind of situation, the person's objecting, that's about it. They're objecting, there's not very much more we're going to be talking about other than to make sure they're in an appropriate setting. There's a CCP 211 already in place, so it's not a question of whether or not we have somebody who really shouldn't potentially shouldn't be there. So so I always do that. I think it's helpful to the court because they know right on the way what we're doing. And this is actually a good point. Every judge has a different way that they approach a case. Generally, they approach the case in the same way. They make sure that the person's in appropriate circumstances and they're not being abused in any way, and we're going about this in the right way. But some judges want to hear a lot of information. Some judges don't want to hear so much information. Some cases, you're going to want to tell them a lot about what's going on, because sometimes you're going to find out something that no one knew about until you actually got there. So then, after I've stated whether or not the person's objecting, I go into the colloquy I had with the individual as far as whether or not they're objecting or not. I always like to put, and this is maybe just a personal thing, I always like to put some quotes in there, what the person actually said. I think it really matters, especially from whether or not they're objecting. And then also when I talk about the orientation questions, like what's your name. Sometimes people really don't even know that, unfortunately. And what's the date, things like that. I always try to put kind of what they've said. This poor individual, as you can see, actually responded almost in the same way to all of my questions, so it was pretty clear that she did need help. Then I talk about, then my next section is the chart. I try to condense, the chart is huge. I mean, sometimes a chart is that thick, and so it's undaunting, and I come from a non-medical background, so the first thing I actually look for as somebody who comes from a non-medical background is I look for the history of how did this person get here? Why is he here? Because sometimes you don't really know, and sometimes that also gives you some insight to what the person was like before. Also, RN's notes are great, and also sometimes you can glean a lot from what the doctors say. Certainly, anything that's typewritten, believe me, it's a lot more helpful. So in this situation, I always make sure that at least I've got the physical diagnosis and also what the diagnosis is as to whether or not the person can make decisions. Sometimes it's right there, and it's a little bit more clear than maybe what the CCP 211 talks about. And in this case, it was important to really review the chart well, because at one point in the chart it did indicate that the respondent was definitely a candidate for rehab. And I thought it was a really important thing to just make sure that that was going to be something that happens, because sometimes, especially if it's an OSG situation, I'm sorry, if it's a office of state guardian situation, at the very beginning, no one knows what's going on with the person. They get into a nursing home, and they should have gone to rehab first, and sometimes they miss the boat. So anyway, and then I have the conclusion, which can be lengthy or short. In this case, it was short. She wasn't objecting. I reviewed I had an interview with the respondent. I reviewed the chart. looked at the physician's report and felt that she was sufficiently competent, and capable of making personal and financial decisions. So anyway, so that was a vanilla type envelope case. Number two, I just put in there because it was, let's see. Number two is ML. I'm going to ML. All right. In this case, I had a pretty short interview with this guy. It lasted all of 30 seconds. This unfortunate guy, who's pretty young, had a mental health diagnosis, and I saw him at Tinley, and I'd been advised prior to that he actually was somewhat violent, and that there were certain situations where he was violent. As a GL, you really do have to watch out for yourself in these situations, but at the same time, you want to do as much as you can for the individual so that you can give the court as much information as possible. And even if the person may have been violent in the past, if you approach them in such a way that they're not going to be violent at the time. In this case, Tinley, you don't go actually into the patient population. They won't let you do that. They actually bring the person out, and you interview them where friends and family would be visiting with the individual. This poor guy, I introduced myself, told him who I was, advised him of his rights under 11A11, but then he read the statement of rights and read the petition and promptly stood up, ripped up my statement of rights, the petition, and handed it back to me and said, "You're not welcome here," which was my invitation to leave. And then it's time to go. You don't want to push him. So sometimes, but then sometimes you can see an opening and it makes sense to go further. So anyway, this report, really like number two, is organized the same way. It's not going to have as much with regard to the interview that I had with the respondent. And at Tinley, it was difficult for me to get to actually get the chart. This is a mental health facility, and this was on a weekend, so it was pretty. I probably would have been waiting for hours until I actually got the chart. But I had really sufficiently, I felt, enough information to give to the judge. Number three, I put in because this is a situation where
Which one's this, Joe?
thank you, AL. Okay, AL, this was an older lady who lived in a pretty nice apartment, had a lot of money, but she also was giving a lot of it away. The public guardian was involved in this case. I could probably have written for pages and pages and pages, but if you look at my report, you'll note that I actually referred to other motions that were before the court that the public guardian actually prepared and was presenting. But I wanted to make sure that the court understood exactly what was happening. In this case, the caregiver, I think in the end, walked away with about $1.5 million, and then left the country. In this case, let's see. You have a question?
Is this missing part of what should be there?
You were looking at
AL.
We're looking at AL. What? Okay, so there's what? Oh, there's a page that's not, which page is it?
Maybe
It
8,
ends
9?
on 7.
8, 9? It ends at page 7.
Okay. Oh, I see. Okay. Well, you know, if anybody's interested, I can always give them a copy.
Should read page 9.
Page, hold on. That's confusing to me. Question while I'm trying to figure out what's going on. Yes?
I was wondering if, Swan
I'm sorry, could you say that again?
recording of the actual
Have I ever made the recording of the actual, that's a really good question. No, I haven't. And you know that there is, and this has nothing to do with what we're doing, but there is a criminal statute that we really have to be careful about here in Illinois about recording things without other individuals knowing what's going on. I haven't. I mean, quite frankly, I'm not the best note taker in the world. I actually have become much better as I've gone from year to year practicing law. But I've never felt that I've walked away from an interview without having enough notes. I always make sure that, like for instance, I've put some quotes in there. I actually make sure that it's in there. And usually people will take, a lot of times, this is the first time somebody's talked to them for more than 10 minutes. So a lot of times people will talk to you for as long as you need them to talk to you for. Yes?
I was just wondering if it was at all helpful, obviously, if I get a big picture of maybe some other things that something's in a video and takes everyone's approval, you know, if you got to 10%.
Well, remember, this is, I mean, I can understand your viewpoint, but remember what we're doing here is we're trying to condense as much information as we can in a small period of time. These reports, these petitions will first come up on the 11 o'clock call in Cook County. It's different in every county, but they'll first come up on the 11 o'clock call. And what you're trying to do is give the court a snapshot as efficient as possible what's going on, so that they can start making decisions that would be in the best interest of the individual. And sometimes you may even at 11 o'clock call, although at what I would call sometimes the slam dunk call. You may have a petition that freezes bank accounts, I mean substantial bank accounts, that as an order's actually ended. So, you know, it depends on what's going on. I think it's just a little over the top to do the video.
Can I just make a comment, Joe?
Sure.
It'd be interesting to get that information. We don't have any way to view it, though.
Well, that's a
You know,
good question.
We're just on computer now in the probate division, so we don't have any way to view that. And as well, when cases go to trial where people object, oftentimes I can take judicial notice of the report of the guardian ad litem as a pleading in the case, so I take judicial notice of it and use it in the hearing. If I had that, you know, disc, I don't know how I would do that, but not a bad thing, but we just aren't able to do it right now. Thank you.
Okay, and with your question, I figured out why I was confused. What I was using was my actual copies of my reports. The handout actually, the numbering is different than my handouts. And basically, it ends at page 3 of my actual report. The next page talks about, and that's why I think people got lost, because, well, actually, the next page talks about you know, what was going on in this particular case. And then number 5 actually talks further about what's going on in the case. You know, and then 6 is my conclusion. And unfortunately, it's not in here, but this is one of my longer conclusions. because this was a very complex situation, and I thought that I had some particular views on what should happen fairly quickly, including, I'm not sure if I actually put it in there, but yeah, I thought it might be in the best interest of the respondent if a TRO or preliminary injunction were placed on the funds that were being siphoned out of this poor person's accounts. So that's, okay, so that's number 3. Number 4 is KV, which is was also a complex case and also seemed to be a situation where the individual was being unduly influenced or financially abused by individual. It turns out a group of individuals. Actually, and I really go through a lot of detail in this in this petition, but you'll notice that the format's the same. You know, I don't vary from the format. That way, it's easier for me to actually write the report if I know what my format usually is, and then I input the different unusual aspects of the case. In this case, this guy had a multi-million-dollar estate, and it appeared that the friends around him were, you know, taking money from him, influencing him to make very, very big donations to churches, things like that. It actually turns out in this case that it was a happy ending. The people who were surrounding him actually were helping him, and at the same time that the CCP 211 was presented that said that he was totally disabled, this guy, this was a point made earlier, because this guy's mother language was a different language than ours. He actually went to his own doctor who spoke his own language, and that doctor said that he was completely capable. Subsequently, we got another medical report that really substantiated the second one. So, and at the same time we found out, and we didn't know this at the time, at least the petitioner did, and I certainly didn't before this report was written, or when this report was written, that there was a trust in place, that the successor trustee would be an individual in a corporate fiduciary, which is a bank. And it worked out that everybody agreed that the best thing to do would be to make sure that the trust was funded, and that the powers of attorney that were set out would be acted upon, which comes to a point that I guess we really haven't talked about, which is that guardianship is supposed to be used in the least restrictive way. It's the least restrictive alternative, okay? So if you're ever involved in the guardianship, you'll understand what I'm talking about. It's very restrictive. And if you can find another way that is in the individual's best interest, that there's a safety net out there, and that they're well taken care of, go that route as a GAL. And in this case, this is what happened. Yes?
That's what I wanted to ask. What is the scope of recommendations that the GAL can make on behalf of the court?
Wide-ranging, really, wide-ranging. You can, I do a lot of things. Most my practice is concentrated in probate, which is, you know, adult guardianships, minors' estates, and decedents' estates. But I do other things as a solo. You can't turn away things. The favorite part of my practice is guardian ad litem work, because I feel like I do good work. You know, I help people, and don't ever feel restricted as a guardian ad litem. If you think you have an idea, you have a point, make it. That's an excellent question. Don't think that you have blinders on. Make the point. People will listen. It may not be correct, or there may be a better way of doing something, but sometimes it will, you know, it's a point that somebody hadn't even thought about. Yes?
Is there an example of this statement to respondent?
I actually, it's at the end.
It's
It's
provided
towards-
in your materials, it's, in the materials that were prepared by the CBA,
Well-
it's called Notice of Rights of Respondent. I think Joe and Eve both use a variation of that, but that's, the court form.
The court form.
Right.
Yeah, actually mine's my own form. In the separate materials, it may have been excluded, but I do have an example. Basically, what I do, the way it's organized, is I talk about it. The first paragraph talks about, how this thing got to court, who filed the petition, what is the petition asking for, who appointed me, that is, what judge appointed me, and what I'm supposed to do. Hey, no one else got that. Yes.
Is there any provision that the rights have to be provided in the language spoken by the respondent?
Is there, the question is, and if I understand it correctly, in the language that the individual understands?
Right.
I think it behooves you as a guardian ad litem to make sure the individual understands as much as they can. They may not understand anything, but to understand it as well as they can. And if you believe because of a language barrier that you're not, their rights aren't been given to them, I think it behooves you to make sure that you get an interpreter in there, just like Sherry said earlier, to make sure that they know what's going on.
But there's no requirement. Like I know nursing homes and hospitals now require that you provide, at least the nursing homes
Probate
require
Act
that.
doesn't have a specific requirement with respect to that. Okay, I'm just gonna try to, I got odds and ends. Odds and ends, person versus estate. I'll go quickly. I'm sorry if I go too quickly. What do I mean by that? Basically, you don't need an estate if all the person is receiving is $12,000 a year in Social Security. Why are we bringing this issue up here in a GAL presentation? Because sometimes you can save the individual money, either the ward or the petitioner money, if you realize it's just a person and the person can come into court, that is, the respondent is going to be coming into court and actually appear before the judge. You may not need a guardian ad litem in that case. The 1011-10 actually says that although it says shall appoint a guardian ad litem, it goes on to say that if the court believes it is in the respondent's best interest and consistent with that they don't have to. So if you don't have if it's just a person and the person comes in, that is, the respondent comes in, you don't necessarily have to have a guardian ad litem appointed. And sometimes I'll even call up the petitioner's attorney and say, why don't we go in on an agreed order and see what the judge wants to do. Sometimes the judge does want to continue to appoint the GAL. Attorney versus respondent, we kind of touched on that. Guardian ad litem versus attorney for the respondent. The real difference is that as a GAL, you are looking out for the person's best interest, and you will publicly say what you believe is in their best interest. Whereas, as an attorney for the respondent, you are his or her attorney now. So, although it's important, you are still an officer of the court, and you're still in a guardianship proceeding, and you have to really make sure that the individual is not in a dangerous situation. But you have to be very careful about what you say now, because if the person's objecting, you may personally think that he needs a guardian, but you're his attorney now, so you can't say that in open court. The other thing is that, of course, everything from that point on, if you're appointed as an attorney for the respondent, is confidential. comes under the attorney-client confidentiality. Then OSG versus OPG. OSG is Office of State Guardian, and then OPG is Office of Public Guardian. They're the guardians usually of last resort. OSG is, they'll take a matter, if it's under 25,000, OPG would take a matter over 25,000. OPG will also be involved in cases where there is neglect, physical abuse, financial abuse. They kind of swing in sometimes when that particular situation happens. I had one of my examples here included OPG. The other, and because I have probably negative 30 seconds now, I would advise everybody that wants to practice in the probate division to get one of these. These are great. It has the Probate Act in it. It has a little bit of the Mental Health Code in it. It's got the trust and fiduciaries in it. It's got a lot of stuff that you're always going to be looking at. And it's not that expensive. Any questions?
What is this?
What is this? Oh, that's right. No one can see it all the way back there. It's the Westlaw Probate Act and related statutes. This happens to be the 2008 edition. Any questions? Good.
We're going to take a quick 10-minute break, come back here and present the mock presentation. You can find the report that we're going to be referring to during that on page 47 of the prepared materials. The notice of rights of respondent that Joe is referring to, the court form, is on page 27. We'll see you back here in 10 minutes.
Thank you for your for your attention so far this afternoon, ladies and gentlemen. We're going to put on a little mock presentation of a guardian ad litem here, which is actually a real case. And in lieu of having signs of petitioner, respondent, GL, we have, in the spirit of Halloween, our lawyers have managed to embarrass themselves by putting on a little costume. So you'll see who they are when they step up. But this branch of the circuit mock court is now in session, and the clerk has called the case of In re the estate of RR. Will everyone in the courtroom who's here on the case of the estate of RR please identify themselves for the record?
I'm JR.
JR, how are you connected to the respondent, JR?
I'm the great-grand nephew.
Thank you, sir. And are those glasses for a medical reason?
No, it's just a little bright in here.
Oh, all right. Well, we'd like you to remove them, but if it's a medical reason, you can keep them on, sir. But thank you. And you are, madam?
I'm his mother, and I'm here because I want to be my aunt's guardian.
And have you filed a cross petition for guardian?
I did it today.
All right. Thank you very much, madam. And counsel, you are?
Good afternoon, Your Honor. I'm Eve Epstein. I'm the court-appointed guardian ad litem.
Thank you. And counsel?
Judge Peter Ashmore from the Office of the Public Guardian. We are the petitioner.
Thank you. And Mr. Ashmore, you are the original petitioner, is that right?
We're the original petitioner. We've also filed a petition to suspend or invalidate the powers of attorney that are in place.
All right. Thank you very much. And were you aware of both petitions, Ms. Epstein?
Yes, I am aware of both petitions, Your Honor. I was appointed on October 4th in this matter.
Into the mic.
Sorry. I was appointed on October 4th in this matter, and the petition to suspend the powers of attorney came at the same time as a petition for the appointment of a temporary guardian, which was subsequent to my appointment.
Counsel, can I interrupt you for 1 second? Nephew Joe, is that gum you're chewing, young man?
Yeah.
Do you know that's one of my pet peeves? Would you mind swallowing
No,
that?
I didn't know that, Judge.
Well, now you do, and it is. So please remove that, sir. But
Yes, Judge.
thank you. And I do have to ask, Ms. Guardian Litem, who is the agent under powers of attorney, and are there for health care and property?
Your Honor, the agent under power of attorney for property is in fact the great nephew, JR, who's present in court today. and the successor to JR is NR, the niece, who is also the mother of JR. And to the best of my understanding, there are no powers of attorney for healthcare.
So none for healthcare, but powers of attorney for property.
Correct.
Mr. JR, do you know when those were signed, those powers of attorney for property? Recently or a while ago, sir?
No, they were signed a long time ago, Judge. I think August 2001.
All right, and have you been actively acting as your great aunt's power of attorney for property all this time?
Yes, Judge.
Thank you. And you'd be able to prepare an accounting for the court if you had to, is that right?
I don't know, Judge.
You don't know?
Judge, I'm not the one that took all the money here.
Well, we'll get to that, but are you aware of what the assets are now, sir?
I think so.
Well, when you say you think so, can you give me an indication what the value of the estate is?
Well, it's probably close to $500,000, I think.
$500,000 now. And what was it when you started as agent under power of attorney?
Maybe around $1 million.
So quite a difference then, right? Want to continue with your report then, counsel?
Thank you, Your Honor. The original petition in this matter was filed by the Office of the Public Guardian, and as I mentioned previously, shortly thereafter there was a petition for the appointment of a temporary guardian. And that was granted, so there is currently a temporary guardian in place.
Let me ask for a minute, is the temporary guardian ready to give any report as to the status of the assets, or would you rather wait, counsel?
Well, I'd like to wait. I think the GAL has included a nice summary of what's going on in her report.
Thank you, counsel. Continue then.
Prior to my going out to meet with the respondent, I received from the Office of the Public Guardian various documents, including financial statements and copies of checks. And based on my review of the 27 checks that were drawn on a Northern Trust account titled in the name of Ms. R., the respondent trustee of R's Trust, dated 8/1/94, 17 of those checks were actually payable to JR or to his wife or to his children. And for the years from 2000 to 2004, the sum that I saw just in the materials that were provided to me was in the amount of $342,000. A further review of the bank statements caused me some concern because it's clear that there have been transfers of funds from brokerage and equity accounts into this Northern Trust account in order to make these payments out. So in addition to the $342,000, we can probably assume that there's been loss of income based on the sale of certain assets. Prior to seeing the respondent on October 27th, I called her and asked if I could meet with her. That conversation was by telephone. During that conversation, she told me she would not speak with me, and she was very specific that she did not have a lawyer. Shortly thereafter, I was contacted by an attorney who advised Ms. G, who advised me that she was in fact representing Ms. R, and she said that she would arrange a meeting for me. And based on that conversation, I was actually able to go to meet with the respondent on October 27th in her apartment at the Breakers here in Chicago. When I arrived, the attorney was actually there, but she left the apartment and was not present during any part of my interview with the respondent. The respondent is a 96-year-old woman. She's a widow, no children, and has been living at the Breakers for approximately 8 years. She suffers from macular degeneration, but if she had not told me that, it would not have been immediately apparent to me. She was able to get around. Her apartment was immaculate. She was dressed appropriately, and she was clean. She told me that she eats her meals in the communal dining room, although she had a small kitchen. And she was quite adamant that she's a very thrifty person, and that she bought her clothing in secondhand stores. She was not able to give me particularly reliable information with respect to her birth date. She was also confused about the date of her husband's death. She couldn't tell me exactly where she had been employed and the number of jobs that she had had. And she couldn't tell me what the names of her current physicians. She was able to tell me that she did not currently take any medication, although she was 96 years old, other than a multivitamin. It was of greater concern to me, Judge, that she had memory lapses and actually no knowledge or recollection of having created a trust. She clearly did not know that she had made gifts to her great nephew, although she was quite protective of him, said it was nobody's business, that if she wanted to make gifts, that was okay with her. But she was not able to tell me the nature and extent of her estate currently or what it had been in the past. She was quite insistent that her estate could not be more than $100,000. And in fact, going back to 2000, it had been approximately $700,000. She was able to tell me about her income, and she was able to tell me about some of her bills. She did tell me that her great nephew, Mr. R, would come to visit her approximately once a week, that he would go over the bills with her, and that she would sign the checks. I did ask her, was she aware of what she was signing, and she said that she thought that she was. She thought that she was. When I asked her what her position was with respect to an adjudication of disability, she responded that she did not want a guardianship and that she would, quote, not permit the imposition of a guardianship. She was quite adamant that she was going to be coming to court, and she told me that it was not anybody's business how she spent her money, and that she would tell the court that. I did provide her with a statement of her rights. I'm also somewhat concerned, Judge, and I stated this in my evaluation and recommendations, about the role of the attorney who is representing her.
Did you discuss with her hiring of counsel?
She was not really able to tell me, Your Honor, how she came into touch with this particular law firm. She couldn't remember, but she was able to tell me that this law firm did represent her great nephew. So I am concerned about that. I'm also concerned about the cross petition that has been filed, purportedly on behalf of Ms. R, who's present in court today, and where this law firm is also purporting to represent her. So I think we have some questions about conflicts here.
Counsel, let me ask Ms. R a question, if I can, please.
Yes, Judge.
Madam, you are related to the respondent, is that right, as a niece?
I am.
And your son is presently serving as her power of attorney?
Yes, and he's doing such a good job.
I am.
Serious allegations have been made about the activities of your son and his work as a power of attorney. Do you understand that?
I understand, but Judge, he's really never taken anything that she hasn't given to him willingly. My aunt is a very generous person.
Do you understand if you would be appointed as her guardian, you might have to investigate the activities of your own son? Do you understand that?
Well, I guess so.
You guess so that you understand it, or would you be willing to do it, or both?
Oh, I'd be willing to find anything that's wrong that he's done, but I don't think he's done anything wrong.
All right, thank you, madam. Please continue, counsel.
In conclusion, Your Honor, it's my opinion that with respect to the guardianship of the estate, that based on the respondent's inability to comprehend nature and extent of her assets, and also some of the questions about transactions that have occurred in the past years, and the fact that she's not clear about the gifting, which is of a substantial size and could affect her well-being into the future, that I believe that she needs the protection with respect to her estate. However, with respect to her person, Your Honor, I do understand, and I have reviewed the CCP 211 of the physician, Dr. A, who went out to examine her, and has given his opinion that she's totally incapable of handling either her person or her estate. I personally did not see anything. I was not able to observe anything, and I have no information, which leads me to the conclusion that she might require a guardian as to her person, but in deference to the physician's report, I would ask that possibly we have an independent examination so that we can get some additional information.
Counsel, at this time, do you have any concerns about her physical well-being or her living arrangements?
I am not concerned about her living arrangement and her physical well-being. I do believe that the people at the Breakers are monitoring her well-being. And my one concern was that she had very swollen ankles, and that might be something that should be attended to, but she's also 96 years old.
All right. Counsel, as far as family visiting with her, are you concerned about that at all?
I am not concerned about them visiting with her. I am very concerned about them having any access whatsoever to any information concerning her estate. I do think that she is close to them, and she would suffer if she was cut off from them, at least for the immediate future.
Yes. Public guardian probably making some request as far as freezing her assets.
So moved, Judge.
Thank you, counsel. Now, niece, madam, you were a litigant in this proceeding. You filed a cross petition for guardianship, that's correct?
I did.
Yes, and I would rather that you not discuss this case when you go to visit your aunt. Do you understand that?
I do.
And do you agree with this court that you will not be discussing the case when you visit your aunt?
But my aunt, she's very upset about this. And after
She
all...
brings it up, Judge.
All right, well, if she does bring it up, do you think you'd be able to redirect her to another topic?
Well, how do I do that?
Well, maybe you'll talk to the guardian Litem after court and she'll give you some hints on how to do that. But just discuss any other thing that may be going on during the day or something about her. Because again, I don't want there to be any undue influence about what her opinions are. So madam, do you assure me you will not bring up the litigation on your own?
I won't.
All right. Now, Mr. Great-Nephew, are you going to be represented by counsel or will you represent yourself, sir?
I don't know, do I need a lawyer?
Well, you'll have to decide that for yourself. This is not a criminal case, it's a civil case, but you're going to have to make a full accounting of the money that has been spent during the time of your power of attorney.
I don't understand, Judge. She gave all this money to us as gifts, and I don't understand why back in October, my powers were suspended.
The court suspended those powers, did they not?
Yes, Judge, and I don't understand that.
Well, a very large percentage of her estate has been diminished. Would you agree with me on that, sir?
Through gifts, yes, Judge.
So now here's a woman, 96 years old, that has not as much money as 50% less money than she had a few months ago, and she has to live on that. So I'm concerned about the actions that you've taken relative to those funds, sir.
But they were gifts, Judge.
Were there any gift estate taxes or reports filed in that?
I don't know, Judge.
Well, that's your responsibility as power of attorney to handle all these things, is it not?
It is?
That's the usual answer, let me tell you. Did you file income tax for her in the last few years?
No, I thought she was supposed to do that on her own, Judge.
Do you know what it means to be an agent under a power of attorney for property?
Well, sure, I paid her bills.
And that's all?
I thought so.
All right, well, I'm glad I suspended those powers of attorney. So you'll have 21 days to provide a full accounting, sir. If you want to be represented by counsel, feel free to hire counsel of your choosing. And again, no other concerns about the well-being of the alleged disabled person, is that right?
That's correct.
All right.
And we do have a temporary guardian in place, Your Honor. So I do feel that at this point, we're safe and secure.
All right, thank you very much. We'll set it over for 21 days for your accounting there, Mr. Sunglasses, and hopefully that's before the temporary will expire. Thank you.
Thank you, Judge.
You know, if I could just add, this was an actual case that actually was in front of Judge Connors, and I was the GAL, and actually Susan Kennedy.
And I wasn't the bad nephew.
Susan Kennedy was involved in the case because she actually represented the great nephew. And this case was actually settled. There was a guardianship proposed, and there was a fairly lengthy process of negotiation that wound up with the nephew, or the great-nephew, having to repay certain amounts and agreements with respect to the monies that were taken. So it was pretty complex, but, and then unfortunately, she passed away. Just when we had everything sort of taken care of, which is the way these things happen quite often. But I think that she actually was quite content, and things worked out very well for her toward the end of her life.
Okay, and last but certainly not least, Judge Connors is going to present kind of a view from the bench. Judge Connors received her Bachelor of Arts degree from Loyola University in Chicago. She received her JD from the Illinois Institute of Technology, College of Law in Chicago. Her judicial experience includes traffic court and domestic violence court in Chicago, Illinois 5th Municipal District Court in Bridgeview. And currently she sits in probate division here in Circuit Court of Cook County. Her commitment, as all of these panelists, her commitment to public service is quite impressive. Her commitment and concern for the success of the pro bono GAL panel make it a pleasure to serve as that panel's director and to work with her and its administration. Judge Connors.
Thank you, Peter. And let me congratulate all the lawyers that have participated in this program this afternoon. They are all excellent lawyers and wonderful guardian litems. I'm just going to do a few little bullet things for you this afternoon. I already think you're a great person because you're here today. You've chosen quite wisely. For anyone that even has the inclination and the heart to serve as a guardian litem in the area of disabled is a good person to me. It's a wonderful area of the law. It is. You feel a sense of accomplishment that you've done something for this wonderful person who is usually either, again, elderly or developmentally disabled, mentally ill, the people that are most vulnerable in our society. You're going to be advocating for their best interests, and what a wonderful feeling it is. To a person, the people that I've appointed as guardian litems, even in the pro bono state, Judge, it was really a rewarding experience. I was kind of afraid and didn't want to do it, but once I did, boy, I felt great about it. It's like serving in a jury, you know? You don't want to try to get out of it, but once you do it, you realize how wonderful it is. So thank you for taking the first step, and I hope you continue with this and get on the list of people that we have because, again, I think you'll find it a rewarding experience. If you are appointed, be careful. The last thing I want is anything to happen to any of my guardian litems. I really love you people, I'm telling you, and I don't want you to take any chances. I've never had any guardian litems ever injured except Steve Murphy, poor Steve. It wasn't when he was out as a guardian litem. The case was a father who was petitioning to be guardian of his developmentally disabled son. The son was a doll, but the father had his own personality problems, and poor Steve Murphy, he was out on the street one day and ran into the fellow and he popped him. Oh God, it was terrible. Anyway, he went to criminal court and got a conviction and all that, but I mean, that was totally kind of unrelated to visiting the child at the home or whatever. But out of 13 to 14 years of experience with guardian litems, it's the only incident I've ever really had. I also have one that might have almost got bit by a dog, but please be careful with animals or things of that nature. If you go to a neighborhood where you're a little concerned about your safety, Chicago, and I apologize, I have a terrible cold and I'd be hollering at the lawyer that was sucking on cough drops, so I'm doing the same thing. But anyway, call the Chicago Police Department. They all have senior officers. Every division or every district of the Chicago Police has a senior officer, and usually they're really happy to accompany you unless they're terribly busy. The suburban departments are really pretty good as well. So don't take any chances, please, do not with your safety ever. Also, if you get an appointment from myself or from Peter through CBLS and you can't do it, fine, we'll give another one to you the next time. So don't worry about that. If you reject 2 or 3, then I start to feel like maybe you don't really want to do it. But of course, you have your schedule. You're doing this for free and for the public good. So of course, we'll appoint somebody else. But let us know right away. And have your secretary or staff, if they're monitoring your faxes as they come in and you're on vacation and one comes in while you're not there, make sure someone advises us, because sometimes it does happen where the case comes up and the alleged disabled person is there with 3 relatives from Kentucky and 2 cousins, and oh my God, I don't have a guardian litem report, so I'm so sorry folks, you'll have to come back, and that's a little painful. So, which brings up another point, punctuality, which is very important to me. I don't care, I'm there till 12:30 usually every day, but it's these people that have to wait. Many of the young people that come in that are developmentally disabled are in wheelchairs, or they're speaking out, or the parents have really, especially in the winter, taken on a lot to bring these people to court. So please, if you can be on time, greatly appreciated. Again, not because of the crabby judge, but because we let these people wait and not want to have them waiting in a busy courtroom. So punctuality is important as well. Which makes me think of one case, which was so interesting. I wish I had a guardian ad litem on this case, because it was a developmentally disabled child, well, 18, an adult. It was before the CVLS program, so I didn't appoint a guardian ad litem. Usually they just come in, I read them the rights, we go through it. This young fella, I forget the diagnosis, but what he had was, it was like Tourette's, but it wasn't Tourette's. He just kept saying 2 words. And do you know what those 2 words were? I can't even tell you what they were. The last one was you, the first one. Can I ask your, and he was totally verbal. The mom said, oh, no, he speaks fine all the time. You'll have a conversation with, so up they bring him in the wheelchair. And I said, what is your name? Mm-mm, he says to me. And it's a full courtroom. I couldn't get anything out of him except, And the lawyers loved it, because somebody got to tell me that 20 times. So I just, and for this family, the mother was mortified. I said, can't he say, love you? I mean, would that, and she said, well, the kids at school heard him say it once, and now he loves saying it because everybody laughs and ha ha ha. But anyway, I wish I had a guardian ad litem for that one. As far as any expertise you might have, do you speak Spanish? Do you speak Gujarati? Do you speak Polish? Any other languages? Please let Peter know. Very important, because the question came up earlier, and a very good question. They have to be read their rights and given their rights. They're usually given in English, but they should be read their rights in their language. What sense does it make? You don't get their rights in their language. So it's usually Spanish or Polish. We have had Russian. We have had a number of other unique languages as well. We get an interpreter if you need to come to court, which reminds me about interpreters. If you need an interpreter, if the mother and father, say, have a young person are only Spanish speaking or Polish speaking, please call us up earlier. Sometimes these are pro se people, they don't know what to do, so I rely on the guardian ad litem. Please give us a call. We have Polish and Polish and Spanish on call at the Daily Center, but they're very busy. So if you give us a heads up, I'll have the Polish or Spanish or whatever interpreter you need on call. We've had Chinese and Mandarin, whatever, it's very interesting. Sign interpreters as well. If a person can sign, very important for that alleged disabled person to get their rights in signed, so we have a sign reporter or translator as well. So please let us know about that if you need that. I do like courtesy copies. Actually, the lawyer said, Judge, your clerk told me you didn't like courtesy copies. What? How could that be? But what I don't like is when people charge for providing me with the courtesy copies. I don't like the disabled person paying $50 so I can read it before court. But anyway, you won't have to worry about that if you're doing it pro bono. So please, if you can, get me a courtesy copy of the report. I read every one of them, and it's nice so that when the case comes up, I know it's happening already. But they're usually not that long, and if you can't get it to me, that's okay, and I'll read it while you're kind of giving it to me. And as you notice, when Eve was giving her report in our scenario, she didn't read every word, and it was a very, very lengthy report. You don't have to read every word. I can pretty much get the tone of what you're talking about. If it's 2 paragraphs, go right ahead. But we have a very busy courtroom, and sometimes I'll have a new guardian ad litem that will page 2, and then they're all waiting and kids are screaming. So I can get it. If I get it ahead of time, give me the high points, if you would, please, of the report. And if there's something that a point you really want to make sure you emphasize that, and I'll be sure to get it. We have 20,000 cases presently pending in the disabled adult calendar. 20,000 cases, 5 judges, so do the math. We each have about 4,500 to 5,000 cases. We are pretty busy. The reason I bring it up is recently I was at a national guardianship seminar and was on a panel of judges from all over the country. And they would talk about, they had 500 cases on their call, or 50. And one fellow from Texas had a small call, and he said, well, plus I have investigators, and I have social workers, and I have people that review the accountings. Oh my God. And I said, I have pro bono guardian ad litems. Thank you, God, because we wouldn't be able to survive without you. The work that the pro bono guardian ad litems do for me is incredible. I would never know any of this information about who's not taking care of them at home, the squalor they're living in, what money has been stolen from them, and how the mortgage hasn't been paid. I wouldn't know any of this. I don't have the luxury of time to go into the detail that you are able to do for me. So thank you already for the work you're about to do, because you do the work of 3 or 4 different people, and I rely on you to do that. Now, the people that appear in front of me, I'll see how you do the first time, see how you do the second time. If you don't do the job for me, I don't appoint those people again. So I like high-quality guardian items, and here they all are, and many more as well. But it's such an important area of the law, I can't take a chance. I mean, I've gotten 1 or 2 page reports at times, and I'll say to myself, ooh, that's too bad, I'll never see you again. I don't have the luxury of, well, Judge, they seem kind of lucid, and they seemed okay to me, and why don't they need a guardian? What? Did you read the doctor's report? Did you talk to them about anything? And you get to learn something that's called confabulation. People that have dementia, a lot of them start to kind of make up things and just talk off topic and kind of fill the void, and you think, well, maybe they are okay. You've got to go that extra step, asking the next question and the next question, so you can observe how the dementia has affected them. As far as the report, again, the standard is, are you fully able to manage your estate in person? That's the standard in the Probate Act. So it's nice to see that, and in the reports that we saw, the guardian lines would tell me that. The next part of it is, are you partially able to manage your estate in person? We have plenary guardianships, which is full guardianship, limited guardianship, which retains in them some decision making, and then gives the guardian other decision making. We also have what's called temporary guardianship, which applies when there's an emergency that there needs to be quick action about. And if any of you have any medical background, I've got to mention that, like Ms. Kennedy here, and Eve has expertise in Medicaid and Medicare, so it's nice to know what your expertises are, because if you have a medical background, I want to know that as well, because a lot of times we have emergencies about amputations, about blood transfusions. It's nice to have someone that knows something about medical, so that when you go to the hospital, it's not, you're not starting from square one, you know the lingo. As far as powers of attorney, they've been mentioned. They are a wonderful godsend on one hand, they are brutal on the other hand. There's been more abuse, I think, of the power of attorney than good. I mean, it's incredible. So you must inquire. Please inquire. Do you have powers of attorney, ma'am, or are those people on Exhibit A? And if you know anything about powers of attorney, it will come out eventually, but it's wonderful when you come to court, if you can make the report and even get me copies of it if you can, or advise me as to who you think are named as agents under various powers of attorney. Pretty much those are the high points that I wanted to cover. Any questions for me or anything about the scenario? Way in the back? Yeah, if the petition's for guardian of the person and estate, I want to know about all assets of the disabled person, and even though the trust technically is outside of the purview of probate because it's governed by the Trust and Trustees Act, do they have income coming from the trust? What's their, what expectancies, what right do they have to any of that? So I want that information. Yes? Yeah, it depends. Like that one I told you about, the young kid that would speak out and call out to me in court. I wish I could, that would have been nice to have that family stay home and they didn't have to come and be embarrassed in court. But again, we're trying to do more of those through CVLS because it's nice to have these extra people that can do that. Those people can stay home, they don't have to come to court. So it depends. I mean, if I feel like, my 4th CVLS this week, I better lay low on those folks for a while. I will just let it go and I'll let the people come into court. Sometimes people like the court experience. The people that are, young people that have Fragile X or Down syndrome, I think those folks like to come to court. Some of the ones that are really high functioning, they love it. And they love talking to me and we chit chat about their habits and their hobbies and all that. So for those, I don't think it's any inconvenience. But people that might have a real bad developmental disability or in wheelchairs and not verbal at all, yeah, I want to get a guardian litem out there to talk to them so they don't have to make the trip downtown. When they don't need an attorney. They can do it. Yeah, I would talk to my clerk, and I hope she asks everyone you've got to get a return date. when the summons is coming back, when people are supposed to appear. And she'll say, are you all coming in? Is the respondent coming in? And I hope she asks everybody that. And she'll write on the top of the petition that I get, respondent will be in court, or respondent will not be in court. So I will know when I get that to appoint the GAL. If they're coming in, and I think, well, maybe I'll see these folks, I won't appoint a GAL. So I should know that. Way in the back? Some insight into the dementia issue. There's something called a mini mental status exam, which you can probably all get a copy of, which is a basic, what do you call it, Susan? Diagnostic tool that doctors use to diagnose dementia. So you can get those easy, and you can probably get it online. Mini mental status exam. Is that the formal name?
It is,
Yes.
but actually, it is a formal evaluation. It does not, though, require any of us to do the whole thing. I think the basic questions are orientation questions. I think Eve touched on those. You know, what's today's date? Can you read the clock? And then 10 minutes later, ask her to read the clock again if she can't do that. But the formal mini mental requires them to draw a clock and to put hands on a certain time frame. I mean, it's a little more complicated, but it is a good starting point, and you will see that in many CCP 211s. You'll see the doctor has done a mini mental test and has given a score.
Yes. No. What happens is the CCP 211, the doctor's report is removed. Once I review it and make the adjudication, it's removed, it's kept in a separate place in the clerk's office, so that's not public knowledge. Sometimes people do ask to seal the files, special provisions for people with AIDS, that was a big deal a couple of years ago. I haven't had any requests for those recently, but they are public record. Yes, ma'am. Judge Brzezinski's procedure is that if you want to send in a letter to him and put your resume in there as well, and we have a monthly meeting of judges, usually the first Monday of every month, and we go over those people that have submitted applications. Maybe some judges know those persons and can comment on them, and go from there.
Judge, you mentioned that the CCP 211 is removed from the file, but the report is not. What would you like in the report vis-a-vis the diagnoses, and are there things that you should leave out of the report since it is a public record and the CCP 211 is removed?
I think you have to put the diagnosis in the report. That would be a complete report. So you don't have to go into graphic detail about things, but you have to give the diagnosis. I think that's appropriate. And yeah, I've never had that issue come up. Most people, again, it's public record, so if they want to have it sealed, we tend not to seal files, though. I mean, the case law is pretty strict about going out of your way not to have sealed files and make sure everything is public record. Yeah.
The city demonstrated really well, but unfortunately sometimes these cases can be very confusing, and you can have multiple cross petitions and unfortunately lots of family members bickering, and often it turns out to be one person's word against another. So I'm sure after years of being in GAL, you become more skilled in determining who's telling the truth. But for those of us who are newer, is it important to the court that the GAL always arrive at some sort of ultimate recommendation?
No.
Or is it enough to kind of divulge all this information?
Just give me all the information. And you'll see, as the cases move, as this particular case, or your case moves along, then you get to get the feeling for what people are really after. You know, the one that's so strident is, I want to be the guardian, I want to take care of mother. Then 60 days later, have you been to see mother? I work, I've been very busy. Well, then maybe you don't care about her so much. So if you don't have the history of doing it for a long time, you'll pick it up on every case. It's amazing how that happens. Sir?
I'm totally new with this, so we talked about the GAL. You say you have a right to 6-person jury trial. I take it that's something that comes after this hearing. There is one
Well, the guardian ad litem will tell the person you have the right to a jury, and if they assert their right to a jury, they get a jury.
It's on the day of that hearing.
No. The return date on the petition is the date when we see if they were served by the sheriff, special processor, whatever it is. Then I have jurisdiction to move forward. You do not get a jury on that date, no. I've only had 3 maybe in 13 years, but we do have them.
And as a GAL, do you have subpoena power? If there are things that, for example, somebody refuses to give you a power of attorney, can you give them a subpoena?
You just come into court and say, Judge, I asked for the power of attorney, they didn't give it to me, and I'll order it. You don't have to worry about subpoenaing that. But sometimes if there are documents that have to be subpoenaed that I can't seem to get my hands on, Guardian Litem can probably do that, but rarely. But it does happen. Yes, ma'am.
For those of us who are in probate court quite often, but in a different role, say representing banks or other parties, to what extent do you take into consideration a conflict of interest that we may have in appointing us as a GAL?
Take it greatly into consideration. I would hope there isn't any conflict of interest. Yeah, we need to know all the background, the history of things. So, yeah, I'm not thinking of what example could be offered, but yeah, we want to know if any conflicts exist. If someone was handling a trust and mishandled it and now wants to be the guardian of the estate, that kind of thing.
No, I mean for the attorneys. I, for example, represent a lot of banks. And when the issue of serving as a GAL has been discussed, I have been told by at least one bank trust officer, you can never be a GAL because you know the workings of the bank, and it would be a total conflict of
The
interest.
secret inner workings of the bank. I don't ascribe to that. If your bank is being asked to be appointed, of course you couldn't be guardian litem in that case, but I don't see why that, I just don't agree with that. Anybody else?
No.
No. Very interesting, no. Secret bank things. Anybody else? Well, thank you, everybody. What a great audience, so.
Thanks for coming. Again, I'll stay around here for a little bit if you want to. You can take those volunteer signups and send them in later if you'd like, or I can answer questions for a while about CBLS.